Sure, good evening, all. This is Ajay Giri, and I'm a technology consultant. I'm working with one of the reputed firm as a data protection officer. So, today we will discuss about Article 5. Article 5 says how we will process personal data, at what principle we will process, or at what ground we will process personal data. So, GDPR has set out 7 key principles. The first principle is lawfulness, fairness, and transparency. Second principle is purpose limitations. Third principle is data minimizations. Fourth principle is accuracy. Fifth principle is a storage limitation principle. Sixth principle is integrity and confidentiality principle. So the last one principle is accountability principle. So we will discuss now lawfulness, fairness, and transparency principle. So see, to being a lawfulness, there be a sixth ground, and it has been given in Article 6. We will discuss later. So we discuss about the fairness. What is the fairness? Fairness means whatever you have collected the data, it should not be cheating, or it should not be unbiased. It should be a decent way, so that anybody can understand by using the common sense that it should be like that. For an example, suppose we are Zomato, and we are collecting from personal data. So at the part of the data subject, what they will understand that they have collected my data to deliver the food only. The moment I will use those data to another purpose, then it is not the fairness. This is the meaning of the fairness. And what is the transparency? So transparency is a fundamental link to the fairness. Transparent processing is about something being clear, open, and honest with the people from the start about who are you and how and why you are use their personal data. It means that whatever you will do with collected data, you will have to tell the data subject. And how you will to tell the data subject? By updating privacy notice. So now we will talk about purpose limitations. So see, whatever you have collected the data, that must be for the particular purposes. You need to record your purpose as a part of your documentation obligation and specify them in your privacy policy, as well as somewhere it is called privacy notice. So see, whatever you have collected the personal data, that should be for the particular purposes. You cannot use it the second one purpose that is not relevant to the first purpose. You must be clear about what your purposes for processing are from the start. So in the GDPR, Article 5(1)(b) has given some provision related to the purpose limitations. So as per this provision, it is mentioned here, personal data shall be collected for a specified, explicit, and legitimate purpose, and do not further process in a manner that is incompatible with those purposes. So for an example, a doctor discloses his patient list to his wife, who runs a travel agency, so that she can offer a special holiday deals to the patients needing recuperations. So doctor, the first they have taken the data from the patient, their name, their contact details, and their medical history they have collected during the consultations. Now he is disclosing to the patient list to his wife, who is a travel agent, to offer a special holiday deals to the patient who need recuperations. So here the purpose is not incompatible. First they have collected to consult as a doctor. Now the whatever they have collected the data, now they are transferring to his wife, that it's for another purposes. So these are the violations of purpose limitations. So the third principle is data minimizations. It has been given in Article 5.1c. So what is the data minimizations? See, you must ensure the personal data you are processing is a very adequate, relevant and limited to. What is the meaning of adequate? Adequate means sufficient to the properly fulfill your stated purpose. Means that it should not be more than, it should not be the less than. Relevant means it should be a link to the purposes. For an example, I am collecting the data for recruitment purposes, so it should be related to the that purposes only. It should not be related to the medical purposes and the purposes. Limitations, limited to means what is limited to necessary. You do not hold more than you need to for that purposes. You should not collect it. For an example, for taking admissions, we need your applications form, your mark sheet, your certifications, your guardian's consent. This four set of document is required by any of the college. For an example, I am just taking. Now, the college is taking an extra document that is related to the family details, that is not required for that purposes. So that is, while collecting that extra data, is a violation of data minimizations. It's very identical to the storage and purpose limitations, but it has a differences as well as. So the data minimization principle is always identical to the third principle, adequacy, of the 1998 Act. The main difference in practice is that you must be prepared to demonstrate you have appropriate data minimization practice in line with the new accountability obligations, and there are links to the new right of erasure and rectifications. So in simple terms, we say what is data minimization. So as per the article 5.1c says, personal data shall be adequate, relevant and limited to what is necessary in relation to the purpose for which they are processed. Data minimization. So I said adequate means it should not be less than, it should not be more than, it should be equal whatever the required. Relevant means it should be linked with your purpose, and limited means the exact. There be four set of document required, then the four only. You should not collect more than that. Otherwise, it will be violations of the data minimization principles. So I am taking another example of data minimization. Suppose an employer holds details of blood groups of some of its employee, and these employees do hazardous work, and the information is needed in this case of incident only. Now the employer has in place a safety procedure to help prevent incidents. So it may be that this data is never needed, it might be, but it still need to hold this information in case of emergency. Now if the employer holds the blood group of the rest of the workforce, through such information is likely to be irrelevant and excessive, as they do not engage in the same hazardous work. I mean, some of the people is working on the hazardous area. and for the safety of that employees, the employer has taken the blood group of the entire employees. Now it is not required, it is required for those who works under the hazardous. Other employees are not required to take the blood group. So while taking extra or unnecessary, it is a violation of data minimizations. Now, the fourth principle is accuracy. It has been given in Article 5.1d in GDPR. What is the meaning of accuracy? Accuracy means correct, updated. So, you should take all reasonable while collecting the data to a step to ensure the personal data you hold is not incorrect or misleading as to any matter of facts. So you may need to keep the personal data updated, although this will depend on what you are using it for. If you discover that the personal data is incorrect and misleading, you must take reasonable steps to correct, or you should erase those data as soon as possible. While collecting the data, you must carefully consider any of the challenges to the accuracy of the personal data. So you have to ensure the accuracy of any personal data we have or not. If it is not there, then we should correct it or we should delete it out. Otherwise, your purpose will not be solved. So you will be penalized through the accuracy as well as the purpose as well as. So taking an example of this principle, if an individual moves house from London to Manchester, a record is saying that they currently live in London will obviously be inaccurate. However, a record is saying that the individual once lived in London remains accurate even though they no longer live there. So it means that one record is saying an individual has been moved from London to Manchester currently. Now the second record is saying that he was lived in earlier London. Both records are correct and accurate, but you should have to update the latest one. So in this accuracy, there be also aligned with some of the mistake happens by humans. For example, record of mistakes. So suppose for an example, I booked a book from Flipkart. Now the Flipkart has taken my mobile number and the address and everything they have taken. Now suppose it has been cancelled, it has been wrongly, they have invoiced in the wrong address. Now whatever they have billed to the wrong address, they have to cancel it out, they have to raise another invoice to the correct. Now he has to maintain both of the invoices as per the the accuracy principle. You should have to update only the updated ones, which is the correct, but here is one is the correct and one is the incorrect. So it has been, it is a practical, it's a practice that it will be happen in any of the organization due to the cause of the negligence, it will be happens. So on those part where there is a human error, so on those part you will have to keep both incorrect and correct, so that can be identified that the previous invoices was incorrect due to this, and now they have raised another one that is the fresh one and that is the correct. So while keeping those incorrect details is also here is is a good fair enough, and it will not be penalized. It will not be apply the principle of the data minimization and also accuracy. It will not be applied. You will have to both. So there is often confusion about whether it is appropriate to keep record of the things that happened which should not have happened. So individuals understandably do not want to their records to be transist by, for the example, a penalty or the other charges that was later cancelled or refunded. I was giving an example also. However, you may legitimately need your record to accurately reflect the order of the events. In this example, that a charge was imposed but later it was cancelled or refunded, the keeping a record of this mistake is its correction might also be in the individual in the best of the interests. We can keep the both, whether the first was incorrect and the second was the correct. So as per the accuracy principle, you will have to keep only the correct one, but here is a different cases. It has been raised by the error of the human. It will be happen at the day by day, I mean regular practice, it will be happen in one of the two cases. So on those cases you will have to keep both. It will not apply to the accuracy principle or the data minimization principle. So now we will discuss on a storage limitation. It has been given in article 51E of GDPR. So what the storage limitation is? A storage limitation means you must not keep personal data for the longer than you need it. I mean, so the personal data you are recording longer than the required, it will be penalized through the storage limitation principle violations. So you need to think about, are you able to justify how long you will keep the personal data? It might be, it depends upon your the business requirement, and you will have to take care of the legal requirement as well. As for an example, income tax is the data is required for the 5 years. It is the legal requirement, but it is not required for the business for that longer period. But the legal requirement is saying that you will have to keep, then you will have to keep. It is also valid. So you will have to analysis the both, whether it is required for the business or the legal, whichever is later or higher. We will have to keep those till the time we can keep it out. For an example, I just gave that income tax. The business requirement is only 1 year, but the legal requirement is saying 5 years. Then we'll have to keep the 5 years as well, as that is also valid. So this is the reason. So this was the storage limitation. Now we will discuss about integrity and the confidentiality of the. So integrity and confidentiality is also called as the security principle. The meaning of it, you must ensure that you have appropriate security measures in place to protect the personal data you have collected. Meaning of this, you should have a appropriate and security measurement in your organizations for those you have collected the personal data of any of the individual. This is the integrity and confidentiality principle of the GDPR. Also, we known as this principle as a security principle. The last one is accountability. Accountability is nothing else. Whatever we have discussed in Article 51A to E and the F, integrity till the integrity and the confidentiality, we are accountable for those if we are processing the personal data. If any of them is violate, then we will be penalized through the those appropriate breachment. So this was all Article 5 about processing of personal data. principles and the grounds of processing personal data. So we have discussed about it. So thank you for watching this video as well as, and I hope you enjoyed a lot during our lectures. If you'd like this lecture, then definitely you will share and also subscribe this channel. Thank you for watching.